Welcome everyone. Thank you all for joining up. We've got Rick Maurice with us this evening. Now he's probably known to most of you already. He's done a fabulous job, you can see already from the paper that we've sent around. He's put together so much material for us. If any of you are anything like me, the new family law rules are currently the most frequented site on my website browsers. So I think that this evening should be a wonderful help to all of us. With that, I'll hand over to Rick, and thank you very much once again, and let's get started.
Right, folks, thanks for coming and welcome to your nightmare. That was a joke. Okay, what I've done with the papers was I originally was going to do one that kind of integrated the rules with the practice directions, but then I realized that that wouldn't work because the practice directions are going to change. So the first paper is basically the rules with some references to the practice directions, but that's the reason for it. That 10 pages will probably get you up and running in terms of just how to get a case going and the many hurdles that are now in place, together with, along the way, new things that have been introduced, which I think they're pretty burdensome, but I think you're going to have to be aware of them. The anecdotal information I'm getting is that the registrars in particular, judicial registrars and senior judicial registrars have been told to apply the rules pretty strongly or pretty strictly, hoping that there'll be better compliance. And I've already seen some evidence of that where lawyers trying to proceed without having taken some of the steps have been basically told they can't, and just to wait and come back again. So it does mean that you've got to be ready and aware of what might happen. Now, just old barristers are supposed to give you some anecdotes, so I'm going to. They're very short. There was a judge called Justice Hogan, and in fact, when I first started practicing as a legal aid solicitor in 1985, what they used to do to us, because I worked for the Commonwealth Legal Aid Office, which was a completely different entity to what we have now. And what they used to do was to send us up there and sit in court, if you like, the call-over court or the duty court, and be there to help. And basically, if there was a problem, the judge would just say, you go and see Mr. Maurice and he'll fix it up. But it also gave me the opportunity to watch and to learn. And I watched and learned several things. One was there used to be this animal called a Section 87 deed. And you can think of it as a financial agreement that a judge had to ratify. That's basically what happened. And in some circumstances, it was hard to get them through. And I remember on one occasion, I won't name this particular judge, but anyway, he was Margaret Whitlam's brother, for what it's worth. This document was handed up to the judge, and the judge started to say, I approve this pursuant to, and I'm sorry, Your Honour, that was his financial statement. Here's the deed, you know. So that was a bit embarrassing. The second story I can tell you was Justice Hogan, who was a very tough judge. And in those days, some judges were much tougher with making solicitors accountable for things that they didn't like. And what Justice Hogan did was that if affidavits weren't filed as he'd directed, so he'd bring you back to see if you'd done it, he just ordered costs against you, against solicitor after solicitor. And sure enough, after a while, people got the message that in his court, you had to comply with his directions. I have a feeling that some of that has flowed through to the present day, because you can see there are references to a few things, but in particular against consideration about making cost orders against lawyers. I don't think it's a good idea, but anyway, it's in there. And that's something else to be wary of, that you may be accused of something and may have to wear it. The third anecdote and last one was in the days of child maintenance. This is before the child support system. And keep in mind that in those days, everything was dealt with by a judge, a family court judge, everything, when it came before the court the first time and thereafter. that particular judge, Justice Hogan, had a simple way of ensuring that child maintenance was paid. He'd say to the father, have you got a car? Yes. Did you drive it here? Yes. Can I have the keys? Sure. And then he'd just get the court officer to give it to the wife's solicitor and make an order transferring ownership to the wife. Good system. Anyway, so as you've probably seen, the aim of the new rules, the primary aim, I think, is two things. One is to clear the backlog, and the other is sort of in aid of clearing the backlog, is to try and get cases out of the system as much as possible, which means both via arbitration and via alternative dispute resolution. And as you've probably read, there's a requirement to have take genuine steps, which personally I think means, although it's not mandated, that judges will expect alternate dispute resolution to have taken place before you commence proceedings. And certainly within 5 months of commencing proceedings, you've got to do it, one way or the other. There is a view that's held across this country, but not necessarily in this state, that lawyers are holding up settlements, and that once people can be sort of removed from the influence of their lawyers through ADR, that cases will probably all settle. And I think that's one of the sort of subtexts that's happening here, is this idea of dragging things out of the system. And also, I've talked about the arbitration system. That's been properly tightened up. It was the old rules were really written at a time when not much work was being done by arbitrators. Now they've tried to do that to try and get those cases out of the system. And it even contemplates arbitration without the court bringing court proceedings at all. How that's going to pan out, I'm not sure. It's going to depend on the quality of who the arbitrators are and the approach that they take, and what attempts are made to prevent their awards being registered. But anyway, they're the two sort of angles, I think, that are being looked at. And then along the way, there, as I say, there is this sort of series of requirements that I think will add pretty significantly to the costs of running a case. But nevertheless, I think the plan is within a framework that alerts a party to the cost of running their case. And yeah, I'm sure you've experienced this, that when parties are carried and don't worry too much about paying along the way, the only time they do worry is at the end, when they realize how much they have to pay. But they do have a very different attitude, I think, when they're not directly paying at the time. I think the purpose of some of these practice or directions in the rules is to make sure people are conscious of that and what it's all going to cost them. And that's part of the exercise in mediation as well, when you're trying to reality test people saying, well, yeah, I'm going to have my day in court and that's going to be litigated and I'll be seen to be on top of everything and the judge will accept what I say. The trouble is the cost, the tremendous cost and the delays in getting there. Anyway, so in the rules is this statement about cases being completed within 12 months. And I mean, frankly, I don't think it's going to happen. Sorry. I'll tell you, I mean, everybody I've said that to has the same reaction you've had, which is to smile, you know. But I'll tell you why I don't think so. And it's this, I've heard this phrase, legacy matters, uttered by a number of judicial officers in the FCFCOA. And what that refers to is anything that was sort of in the system before somebody filed something on the 1st of September of this year. And everyone seems to be pretty resigned to the fact that they're going to follow the path that they would have always followed anyway, and that they're not necessarily going to be streamlined in a way that speeds up when they're heard. So you could have a situation which is a bit strange, where let's say you filed a parenting matter at the start of this year and somebody files on the 2nd of September, and they're similar cases, and their case will be heard in 12 months and yours won't. So, but nevertheless, that will iron itself out. So, I mean, legacy matters comprise what, 99.9% of the work the court's got at the moment. And if they're still operating on the same sort of timeline as before, I might sat down to try and figure out how long it might take before we've got only matters filed after 1 September. It's going to take a while. So those slower cases, the old cases, of course, have an effect on the new cases and their time frame. The other thing, of course, is we still don't have sort of a full complement of judges on deck, and we don't have the resources to do things like family reports in a reasonable period of time. So there's no point saying it's going to be heard in a year's time if the family report is available, 14 months from today. Anyway, so they're all those things. I think the 12-month thing is a bit of a sort of advertising gimmick, frankly. I know it's being recorded, I don't care. I don't think they're serious, or it can be seriously done. Anyway, so let's just talk about the pathway of how we get a case underway. You've seen that in broad terms, you've got to have some form of, particularly with parenting, family dispute resolution. With property, I think it will involve some form of ADR. There's a bit of a debate in a property case whether solicitors having a round table conference will satisfy it. As I say, it doesn't say it must be alternative dispute resolution, but I have a feeling that that's what will be required. There, of course, are exceptions, and no one is going to force someone who's in fear of their partner to undertake this kind of thing, or alternatively going to force them to pay for something they can't afford to pay for. But that's going to slow things down. I think by the time you've gone through these requirements, it's going to take many months before you're really ready to kick off, unless it's urgent, in which case it's a bit different. So then there's the duty of disclosure. We know all about that. Basically, all of these sort of provisions luckily have a kind of default in them where if, let's say, the other party is unrepresented and throws your letters in the garbage bin, you still have a way of getting around it by saying, well, I've made every effort to engage this person and they're not interested. So the court will let you off the hook. But what I wonder is what's going to happen if you've got someone that is deliberately trying to stall you, and I can well imagine that someone might do that. Anyway, so then you've got your genuine step certificate, and it's supposed to outline all the things that you've done, and that's got to be provided to the court. And you've got to give a notice to set out those genuine attempts that are needed to resolve the dispute, the cost involved, how long it'll take. I mean, I don't know how the hell you're going to tell a client how long it's going to take, because no one seems to know. Anyway, maybe it'll say 12 months brackets if you're lucky, close brackets. Anyway, so my jokes are going flat today. Is it because of the rules or just me? It's probably me. Okay.
The lockdown.
Okay. Anyway, so you get to the point where you've jumped through all those hoops, and the next step is you've got to actually notify the other party you intend to bring proceedings, and I think they've got 14 days to respond. And it's a very similar situation that if they just ignore you, I think you can then proceed regardless. So it seems to be commonly accepted that these procedures can't go on forever, and at some point there has to be a line drawn, because I think there are certain personalities that just don't want to participate or engage with their former partner, and quite happy to sort of spin it out. So you file the application, and someone goes through it, ticking all the boxes, and decides that you have failed to meet one of the steps. And this is where I'm talking about the court taking a harder line perhaps than in the past. What the court is able to do, or the judicial officer is able to do, is to say, well, this case is going nowhere until you do certain things. And it even says that they can take into account the fact there hasn't been compliance in order to make a costs order. And I think that can be as against the lawyer as well. Again, it's just part of this kind of draconian theme of there's been too much lack of compliance in the past, so let's rein everyone in. Frankly, I think the horse has bolted. It's probably a bit late to start, trying to restrain everybody with this type of thing. And I've just got some doubts the extent to which this is really going to be implemented and what difference it's going to make. Anyway, so so far so good. So you bring your application. People say, "Wow, I don't have to file an affidavit, but you have to file do so many other things." I can't really cost it, but I'm guessing that it's going to be more expensive than it would be to file in the old Federal Circuit Court with an affidavit for sure. Anyway, there it is. The next step is to do a questionnaire. And they're different for parenting and property. For property, they're a sort of cooperative, or meant to be a cooperative document. And it is a little bit like, part of it is a little bit like the traditional joint balance sheet and that sort of thing. I can imagine more delays in trying to get that done as well. For parenting, there's a questionnaire which is individually completed. And I don't know whether you've seen any of these yet. I think they follow a similar style to the old questionnaires. I just have to say one thing. In Canada, I was reading that they were praising our family law system for the first day and the non-combative litigation, all that. The trouble was, by the time they were praising us about it, we'd already dumped it. So I mean, are there any more first days? No. Does anybody really look at questionnaires or anything? No, not really. Anyway, but we're back to the future. I know I sound cynical, but that's because I am. There it is. Okay, so the parenting questionnaire is prepared by each side. The form says that what the content, or warns the person who signs it that what's in there is going to form part of their evidence. We've already had that before, and I do recall people being cross-examined on their questionnaires, but it's fairly rare because by the time the case is at the point of a trial, a lot of water's flowed under the bridge. So there it is. But there it is, and there's no provision to amend it. But it seems to me that if there was some fundamental problem, you would ask a judge or a judicial officer for leave to change it or to amend it. I can't imagine someone saying, sorry, you can't. That doesn't mean that a clever barrister mightn't look at the earlier version and challenge the person, your client, about both versions. You never know. But so I think it's a kind of surrogate replacement for an affidavit. And I think you probably would have struck this, that it's not a good idea to let the client complete it without you at least running over it to make sure there isn't something in there that may be a problem. So that's probably a good idea. Now, so you filed your application, you've really got two paths. One is the path where it's going to work its way through the system towards some sort of final hearing. The other path is where you want some sort of interim orders. And the rules are different between Division 1, the old family court, and Division 2, the old Federal Circuit Court. The reason for the differences has something to do with the origin of these rules. I mean, this is all the inside info I got. It makes sense to me. There was a great deal of dissent about which set of rules should prevail in the new, from the old to the new. And what you found is that in many instances, there are two sets that don't seem to marry up and don't make sense. Interlocutory affidavit is a good example. So for Division 1, it's 25 pages and 5 annexures. In Division 2, it's 10 pages and a maximum of 10 annexures. But anyway, there it is. So you can seek an interim orders in the initiating application. And that's fine. That would then be accompanied with an affidavit. It has to be scrutinised by a registrar or a judicial registrar to determine whether it's urgent. You've got to do a covering letter that explains why it's urgent and referring specifically to parts of the affidavit. And these are things I've told people for years to do anyway. I've just said, put the urgency at the very start of the affidavit, so it's obvious. But anyhow, same thing, I think. And I think at that point, because there's a single entry point, somebody's going to figure out where to send it, either to Division 1 or Division 2, and that's really up to them. If you have filed an application without seeking any interlocutory orders, then you've got to file an application in a proceeding, which is an application in a case, and accompanied by an affidavit, etc. So, I mean, it's pretty much the same as the old system in terms of how to do it. I suppose the only differences are that how urgency will be decided, how dates will be allocated, and the priority, because I don't know whether your experience has been the same as mine. It seems to be very hard to get any judicial officer to give you dates now. It has to go to some team somewhere in Melbourne or something to work out what dates to give you. And that can have some very unfortunate side effects. With a recent one, I think I was telling Jennifer about this, we filed what I considered to be quite an urgent spouse maintenance application, quite urgent in my view, and seeking some injunctions, that sort of thing. That was filed in June, okay, that's pre the new system. But post the new system, it's been to two compliance hearings or directions hearings. And on the last one, which was post 1st September, I asked the judicial registrar to give us a date. Oh, I can't do that. No, I'm going to refer it to the team. So that was today, 12th of October, we're still ready. So that's filed in June, 12th of October, no sign of a date. So they move in mysterious ways, but how that's going to pan out, I'm not sure. It's just that not having the convenience of a judge giving you a date, I think is a real problem. I really do. And I hope that changes. And I expect that some judges will buck the system anyway and just refuse. And if it's really important, that they'll deal with it. Okay, so I've looked at the delegations for what used to be registrars and now judicial registrars, and what used to be senior registrars and now senior judicial registrars, to try and understand what they're trying to achieve. And I think someone has just sat down and said, well, what are the most routine things at sort of whatever level of complexity that we can allocate to them to deal with, so that a judge isn't troubled with it. And that's what you get, basically. The senior judicial registrars can deal with a lot of things, parenting and property proceedings. They can't deal with 44.3. I found that out the other day. And they can't deal with Hague Convention, again, because these are sort of things in the ken of a judge, certainly in Division 1. And they couldn't deal with something like a medical procedure where there was they're seeking the sanction of the court to permit some sort of medical procedure on a child when it couldn't otherwise be done. But it might be worthwhile having a look at the schedule and just going down there, because occasionally I have turned up to court and I have said to a registrar, I don't think you've got power to do that, actually. So they feel very sort of gung-ho about, well, why do you say that? I say, well, have a look, it's not there. Oh, oops. And so it's good to know what they can and they can't do. The other problem I'm finding, and again, I'm relying on my own experience and what people are telling me, is the number of these interim hearings that are being reviewed. People having that experience, yeah. I mean, I don't recall review hearings being very significant, any time in recent history. But it seems that the view people take is, well, I don't like it, I can have an automatic hearing again and whatever. That has two problems. One is it clogs up the system and people's lives, because they go for an interim outcome and they don't get one straight away, and months pass. The average time seems to be months before it's reheard. It's not like, the next day or something. So that's one problem. The other thing is that the plan is to take the load off judges so that they don't have the same amount of work and the same amount of pressure. But if they're hearing review applications all the time, and you might ask, well, why don't they just get rid of the reviews? The trouble is we've got this thing called the Australian Constitution. So because judges have certain status versus registrars who are not judges, their decisions must be capable of being reviewed. And there it is. So unless they appoint lots more judges, there you go. So who's finding the cost disclosure obligations really good? Anybody? No? Okay. So it's got there's a couple of aspects to it. One is this idea that if there's an offer to settle, you've got to give your client, I suppose, the actual net effect of settling. It's probably not a bad thing, because if they've, clocked up $70,000 in costs and the offer is 200,000, maybe it's not quite as attractive as it might, the headline figure might appear, but you've got to do that. And the other aspect is before every court event, you've got to give this kind of comprehensive written notice about what they've spent to date, what they're going to spend to a trial, including witnesses and experts and that sort of thing. And I think it also has to say, because it is filed, where the money comes from. And, and I understand why that's being done, because sometimes people, what do they say, they're running cases with no visible means of support. It seems impossible to figure out how they're actually running their case, given that they say they've got no money and, whatever else. Anyway, so that's got to be done before each court event, and it has to be provided to the other side and filed in court. So it's onerous, and it just means you've got to keep track, probably much more than, well, I don't keep track, but probably much more than you would even normally do, of not so much what you've charged and been paid, but to try and work out what is ahead in terms of the case. And that's, I think, one of the problems, because things emerge that you don't expect, and cases can take on often take a life of their own. So that's pretty hard, but I suppose you just do the best you can. You just don't want someone to note on the file, which apparently they can do, that the costs are out of proportion with what you've previously charged or something. I'm not sure what that's all about. There is, as I say, there is this view that we're in it for the dough, and I keep telling people it's only the love of the law that brings me here, and people react the same way every time. Okay, all right. Anyway, we've got a young lawyer there, I can see, Katrine. Good. Okay. So it says the court may record the terms of any cost notice and any comments it has about costs incurred in the proceedings, including in relation to their consistency with previous cost notices and their proportionality. I don't know what they mean, or what that's supposed to mean, and who's supposed to deal with it. The funny thing is that the court doesn't really have all of that much control over costs. They're not regulated in that sense. So that if someone has the means and is prepared to pay 10 times the amount that your client pays, I don't think the court can stop it. I think the only purpose is to try and encourage some proportionality. So, all right, fast track hearings. My first experience of fast track system was a complete failure, I'm happy to tell you. So we had this incredibly simple matter that really could have been dealt with in an hour. And I won't bore you with the details, but we get before an unnamed registrar, judicial registrar, and I say, hey, listen, can we have a fast track on this one? Have I got a deal for you? I can do this in half an hour each side, affidavits only, blah, blah, blah. Oh, no, I've got to assess the matter, and this is a few weeks ago, it can come back at the end of November and we'll think about it then. And I said, well, can you refer it to the new system? No, it's got to go to a senior judicial registrar. So I call it the slow boat system rather than the fast track system. I hope it works better. But I mean, all of you have struck situations where this idea is great if it can actually be carried out. It's just a question of whether it can. And I'm sorry to sound so old, in the past, I think judges were very good at identifying things that were relatively straightforward and just saying, well, let's, even on a mention of thing, let's do it now. Let's take an hour and fix it, And it really did help sort of clear the backlog. But we live in a different world where everything's a lot more complicated than it used to be. Okay, in terms of listing matters for trial and all those sort of directions, you'll see both in the summary I've done of the practice directions and of the rules themselves, that there's now a kind of formulaic way of doing it. It's not very different to what we've always done in terms of getting everything ready and filing a joint balance sheet if it's financial, filing case outlines and all that kind of stuff. But I think what they're trying to do is to sort of codify it so there's some consistency between different judicial officers. So I didn't see anything new in that, and nothing dramatic, and really nothing dramatic in the way the cases will run or how they'll be dealt with. So the framework is really to support the old system. That's how I see it. So is it a good thing? Why did you ask me that question? Someone's going to ask me, is it a good thing? I've been pondering this for some time. Who said a change is as good as a holiday? Maybe that's my answer. Okay. Maybe.